One of the key authors and proponents of emotional intelligence is Daniel Goleman, who wrote famous articles in 1998 and onwards. He suggested that emotional intelligence accounts for about 67% of the abilities needed to be a successful leader. 67%. That's a huge proportion of skills to actually be successful in your field. And the sense is that this is about twice as important as technical proficiency, or IQ, which is what most people focus upon when they are teaching, especially when training lawyers. And also, interestingly, when they're recruiting, although that has now changed very much because people are putting much more emphasis on EQ. So to be emotionally intelligent is to be able to identify what you are feeling, to know how to interpret that, to understand how your emotions are impacting on others, to regulate your own emotions in order to manage other people's emotions. That's the core of it. So it's not just about being in a corner and being introspective and having touchy-feely moments about your own feelings. It's actually about how you are controlling, understanding, manipulating, and working with and maximizing other people. And if you put that into our work as lawyers, whether it's working with colleagues or adversaries or clients or judges, those are all relationships where you want to be handling, understanding, and managing the other people's emotions in order to succeed in your legal work. It's not about building your own personal relationship for the sake of it. It's actually about being effective as a lawyer. I need to put on record at the beginning that the suggestion that I give a talk on emotional intelligence didn't come from my wife. And also, it remains unclear whether or not Mr. Luthra's insistence on this topic has come from his wife. And that I'm not going to address any further. There are 5 core elements to emotional intelligence, 5 core elements. Number 1, self-awareness. Number 2, empathy. Number 3, self-regulation. Number 4, motivation. And number 5, social skills. I'm going to start to apply some of those to the things that we do in the legal profession. Interestingly, the studies that have been done on lawyers and emotional intelligence show how bad we are at this. And what's really fascinating about this is there's a connection between a lack of EQ and professional malpractice. That has been shown in a number of American studies because of failures of perception and awareness of other people's emotions. So this was a study that was done famously by the ABA, the American Bar Association Standing Committee on Lawyers' Professional Liability. And they said, and I just quote from one of their core reports, they said, at the most elemental level of law practice, emotional intelligence appears to be necessary for attorneys to avoid malpractice liability. Nearly 1/2 of all malpractice claims allege errors relating to professional skills in pre-trial evaluations, negotiations, and settlements. Those are all functions where you have to understand the positioning of your client and their chances of success and your relationship with an opponent. And there's an emotional EQ element to all of that, which in fact, there's a correlation. If you are not understanding what's going on, you may misjudge the situation and then you may give the wrong advice. And then you end up in trouble, which is good news for other lawyers. But that's another story. So that is why the well-known question is put always amongst lawyers, which is, what do you call a smiling, courteous, emotionally self-aware, sensitive, empathetic person at a bar association convention? And the answer is the caterer. Moving on, post-pandemic, we haven't had a need to interact physically with other people for 2 years. We haven't really had a need to understand them directly in the same way, to be in a room with them and to pick up on all the chemistry and to see how they are operating, because all of it has been remote and all of it has been shut down. So we have our interrelationships, We have online hearings, you have online negotiations, you have online meetings, but the amount of communication and the types of communication that we are receiving has been very limited. That means we've been in some truncated version of interpersonal skills, and now we're being thrown back into old-fashioned, full-blooded relationships, and that's where we need to revise on this topic. So let's apply all of this to the role of the lawyer, and my focus is the role of the advocate. But you can be an advocate in many ways. You can be a written advocate and an oral advocate. You can be an advocate in a formal court setting, or you can be an advocate in an informal meeting. That role of advocacy is what we do all the time. We do it with our associates, we do it with our partners, with our colleagues, with our opponents, with our clients, and of course, and with the boss.
Sorry.
So one of the most common and, to my mind, fundamental errors when advocates are being trained is the conception that advocacy is something that is technical and can be taught as a technical subject, and that there is one way of doing it. There are correct things to do and there are incorrect things to do as an advocate. And often when you attend advocacy lectures, you will have 10 things that you should do and 10 things that you shouldn't do. For example, number one will be concise, and number two will be see number one. That's often what people say. You know, there are things that you should be doing, things you should not be doing. To my mind, that is absolutely superficial and of limited use. To be an effective advocate, there is a core emotional psychology element. In order to persuade, you need to persuade not only minds, but also hearts. You can win somebody's mind, but you can lose the case, or you can lose the argument if you haven't won their heart, or if you actively alienate. And what many advocates don't appreciate is how ineffective you can be if you are not liked as an advocate, if you are not on the right wavelength, if you are miscommunicating, if you haven't built rapport, and if you haven't built confidence and trust. So at the core of an advocacy role is an interpersonal relationship between you and the person that you are seeking to persuade. Now, what I've said has got nothing to do with law books. It's got nothing to do with good legal argument, well-structured argument. Of course, all of that you need. But actually, this is a whole dimension that is separate, but it's critical. You can, if you're a judge and I'm an advocate, I can put to you a very clever legal argument. If I do it in such a way that is irritating, that is confusing for you, that makes your life harder because you've got to work it through, I haven't made it clear for you. If I'm doing something like a certain mannerism, which you're finding irritating, if you think in the end that I am not a likable person, it is extraordinary how all those will bleed into your susceptibility to the technical argument. That's just how we operate. And as lawyers, you can reason in all different directions. Many directions are open to you, not in terms of technical argument. So which direction you take is often guided by that whole emotional context. I had a revelation when I started sitting as judge or arbitrator, which I did some years ago, but after a period of time just being counsel. And the revelation was just how irritating counsel can be. I had never appreciated how irritating they can be. Nobody in this room, can I just say, we've done our checks. Nobody in this room is guilty of anything I'm about to say. But counsel, without realizing it, can be irritating because they are not they're not connecting with actually what would be helpful to the tribunal or the judge. Not just in the court setting, this can be with your opponent. It can be with your partner, your associate, your client. What's interesting about the advocate's role is that interpersonal relationship which you have with judge or tribunal is a very odd relationship. It's not just like meeting somebody in the street or meeting a friend. If you think about it as a relationship, you are thrown together as people who have to interact without choosing to be with each other. You're not with a friend or not with somebody that you actually want to be with. You are with them because you're there, because that's the fixture, that's the listing, that is the situation. You're thrown together often in a very intense relationship for a period of time. You're actually in the same room as them. Often it's a room with no windows. It can be a period of time with few breaks and high intensity. And your single task is to persuade. Now, just think of that as an interpersonal relationship. It's a very strange relationship. Or you wouldn't go up to somebody in the street and pinpoint them and focus and say, don't look anywhere else, just look at me. And now I don't know anything about you, but I'm gonna persuade you. I mean, it's just an odd thing, but that's what we do. And we do it in many settings. And so that heightens the importance of EQ, to be able to manage that situation effectively and to get the fruit out of it that you need to get. The truth is that in an advocacy situation, the intensity of that relationship is such that both parties, judge and advocate, or it may be partner and associate, spend a long time looking and studying each other. That's the other odd thing about the relationship. It's so intense that you can sit there and you will spend a lot of time understanding or thinking about everything about the other person. If you're an advocate in court, you'll look at the judge and you'll try and work them out, him or her. You'll try and work out their background. You'll see every mannerism, every physical twitch, and the judge will do the same. And sometimes if, for example, you're doing something irritating, it also gets intensified because you can have hours where you're just staring at each other. Again, this makes EQ so much more important. It's because it's a very, very sensitive, intense relationship. I remember sitting with a judge as a marshal, that's like a clerk to the court when I was training in England, very well-known judge. And I sat with him on the bench just to watch. And there was counsel in front, pouring his heart out in a submission. And it was an all technical submission, and it was done with a lot of force. And there was a break in the proceeding, and we retired to the judge's chambers. And I said to the judge, what did you think about the argument? And the judge said, what I found most upsetting is if you're wearing a waistcoat and you're overweight, your waistcoat can ride up your stomach. And what then appears is an inverted V where your shirt is showing. This is what he had picked up from that advocate. There was a shirt triangle which was disturbing the judge. And this is absolutely true. So fine, he listened to the arguments, but he was very affected by an ill-fitting waistcoat. This is an emotional element which you're not going to see in the law books. It matters. It matters because obviously it's somehow degrading the attention span. Shouldn't do, but we're all human. These things do happen. And so you've got to factor into the way that you behave these other elements. So let me apply the elements of EQ one by one to the role of advocate and consider how in fact it impacts and what you can do about it. First of all, self-awareness. Self-awareness. The ability accurately to recognize your own emotions. That's the starting point of all EQ. So you cannot understand somebody else's emotions and how they're going to react until you've understood your own. Right? That's where we all fail at the starting point as lawyers, is actually understanding objectively yourself. You've got to step back. You have to take a breath and actually observe yourself in every situation. You don't start by observing the others, because the way they are reacting is to you. So to understand that, you first have to understand yourself. And that takes a moment of reflection, the essential first step. And in a court situation, it is actually the task of positioning yourself not from where you are standing, but on the other side of the bench. What you look like, what you sound like, how you appear. and how you are behaving. How are you behaving with respect to the people around you? How are you behaving with respect to your opponent, your clients, the witnesses, and of course, the judge? There is a biological aspect to all of this, which I'm just going to explain to you by way of a footnote. It's an American style, slightly long footnote. The biology of EQ. Our brains are hardwired to feel before we think. We feel before we actually think as a physical process. On average, we will average about 465 different emotions each day. That's what the science tells us. Every day, in terms of emotions that are differently categorized, we will travel through about 465 different ones. And each emotion itself is an impulse to act in a particular way. That's how the biology works. There is a part of your brain called the amygdala. It's a very important part of your brain. That is where you store emotional memory. It all goes into that part of the brain, the amygdala. And that manages our ancient fight or flight responses. All right, that's of course how we are programmed, which is that we're out in the jungle and we're protecting ourselves, and the emotional reaction we have is to fight or to run away, and that's all controlled through emotional responses in that part of the brain. There's another part of the brain which is called the neocortex, and the neocortex is where our IQ is, and that's where our working memory resides. Now, these are two competing parts of your brain. What is very interesting is that the amygdala responds to external data 100 times faster than the neocortex, which is extraordinary. So your part of the brain that's doing the rational IQ thinking is slow compared to the emotional part of your brain that's actually giving you emotional responses. That means if you have a stimulus, your brain 100 times faster will have an emotional response to it and a suggestion for action. 100 times faster than the other part of your brain, which is coming with a rational response. There are some people I know where that balance is even more extreme, but I'm not going to name them at the moment. The fight or flight response naturally inhibits the rational one. So you have to actually think through and past the emotional response to realize your rational response. This is called an amygdala hijack. That's what it's referred to. So when you go home and you're late and you're intoxicated and your spouse is about to throw something at you, you should explain that they are simply suffering from an amygdala hijack. If there's time. That sudden, strong emotion is something that we need to realize and understand as a biological response. And we then need to think through it, because our first response is to do something dramatic, even if we are just in the office and not actually about to be eaten. So there's a biology that we have to resist. There's a biology here of EQ that actually means what we have to do is to recognize those responses, which are coming quickly, and then understand them. And putting that into the setting of self-awareness, that takes us to then understand how what we're doing, how that might impact on other people. Right? So that's a complicated biological way of simply saying you've got to actually take that moment to see how you are reacting to something, to then take the next step, which is how are other people perceiving you and how are other people responding to you. Now, all of this I'm describing, I want you to picture it in the context of your role as an advocate, whether it's in court formally, or whether it's in a meeting, or whether it's writing a letter, as to be able to try and work out and predict and then manage what the responses are going to be. So the second element beyond self-awareness is empathy. Empathy, which is our connection to others, both their perceptions and their feelings. And this is the ability to identify other people's emotions, i.e. putting yourself in somebody else's position and understanding how they feel. In Goleman's famous book, Emotional Intelligence, he said that this is at the heart of influence, this one element of empathy. If you want to influence other people, you cannot do so if you're not skilled in empathy. So this is a transcending of yourself and putting yourself in another's position. If you're an advocate, there are technical steps you need to take here. There are two of them. The first one is you need to diagnose your audience. You've got to assess them, understand them, and diagnose them. What's their condition? The second step is you must then tailor your advocacy accordingly. Now, it takes me back to the moment what I said earlier on, which already may feel like a long time ago. And that is, there's no set list of do's and don'ts. You cannot say you must advocate in this way and not this way if you haven't diagnosed your audience, because audiences require different things depending on who they are, depending on how they're feeling, depending on their background and their training and their expectations. And that's the mistake about advocacy training, is that there is one size that fits all. And again, this is not just in court, it's in any interpersonal relationships, in particular in a legal setting. People say you must read your tribunal. People say you must know your tribunal. Actually, you've got to go much, much further than that. You've got to be your tribunal. You've got to get into their shoes. You've got to get it into their position. It's only then that you will really understand what is needed, what's going to switch them on, and more importantly, what's going to switch them off. There are a number of components to this diagnosis process, right? This may sound obvious, but it isn't. And people kind of skirt over it and they assume too much. So let's do some microsurgery on this. The components of empathy, of actually understanding the people you want to persuade. Firstly, background and experience. What's the background and experience of your judge or your opponent or the person you're seeking to persuade? Cultural, juridical background, perspective. Are they common lawyers? Are they civil lawyers? All of that will impact on their understanding and their assumptions. What's their training? What's their expertise? All right, that's easy. You can look them up. You can actually work out where they come from. If I argue in a court, I argue all around the world. And in arbitration, you have mixed tribunals, people with different backgrounds. I will routinely Google them and understand what is their training, where have they studied. That's easy to find. This is kind of detective work to place them into certain categories. If they're a civil lawyer, I might modify my cross-examination because I don't want to do something which they're not familiar with, which they might get irritated by. If they're common lawyer, then I'll know a little bit more in terms of tools of the trade. If they're not a lawyer, obviously that's very different. That's easy, number one. Number two, personality type. Not so easy. What is their personality type? It's not about training. It's not about background. Are they friendly? Are they formal? Are they old school, traditional? Will I start by saying very, very polite, a polite starting point, or will I start with a joke? Depends. That's all personality type, and it matters. I can start with a joke, and I can tell you routinely from experience, it'll be a disaster. It's my joke. It'll be a disaster, meaning like it's a lead balloon, and then I'm on the back foot already. I can start by being very, very polite. Sometimes people don't like that either if they're very modern and they think this is all nonsense. So personality type. Next, it gets harder. Mood. What's their mood? Are they happy? Are they grumpy? Depressed? Are they humorous? Are they coming in looking troubled? Again, that goes directly into how you are going to present yourself, because that will impact on how they receive it. Next, what are their likes or dislikes? What are their idiosyncrasies? Even as an advocate, this matters. What language do they like you using or not like you using? If you use Latin expressions, are they going to get irritated? Some people do. If you've done the research, you will know there'll be people who will be able to tell you things. When I first started as an advocate before the courts in Singapore, I was told that a judge who I won't name in the Court of Appeal, Judith Prakash, doesn't like you wearing a loud tie. That's important information. That's a like or a dislike. If you appeared before Lady Hale in the UK Supreme Court and you had done your research, you would know not to stack your paper books and folders on the desk in front of you, because she hated that. Why? Because she had designed the courtroom with bookshelves at the back. These are little things. You think, does it matter? Yes, it does matter. They all interconnect together. So we've spoken about background training, personality type, mood, likes and dislikes. And then, of course, any classifiable psychological condition. Depression, anxiety, bipolarism, attention deficit, learning difficulty, autism, schizophrenia, or psychotic serial killer instincts. That will cater for a large portion of the people that I have appeared for, and I will be naming names the day after I retire. And then lastly, for a court setting, it also is relevant for long negotiations, is condition on the first day, and that is level of preparedness. How much have they read before you get up and say anything? How much do they know about the topic? There are those who will come along and give the impression of being well-read, but they are not well-read. And there are those who are very well-read, and you can tell already. And if you start at too basic a level, you switch them off already because they're bored. So that is another level of assessment, is actually where are the other side positioned? Where is the judge positioned at the moment? And therefore, what precise assistance do they require if you're going to persuade them? Now, at this point, I'm just going to divert slightly into the nature of international arbitration practice. Some of you think...
May I just interrupt, sir?
Yeah.
You talked of instinct for killing. Will you put your videos on? We're talking of emotional intelligence over here. He's telling you about the room you're stuck in. Please keep your videos on. It's important, and I'll explain the logic to you. Never mind if you look weird. I look weird. And Purvi, you had your hand up. Come on, friends, put your videos on. We don't want to waste time. And I'll explain the reason. Okay. Not going to keep repeating. Sorry.
So I'm going to give you a little tour into current international arbitration practice. This is not the moment where everybody who is doing other things than arbitration thinks they'll have a quick rest. All right, this is by way of example to show you how this works in practice. I have said that what you need to know, you need to put all these things together, and then you need to know the condition of your audience when you are about to speak. In modern international arbitration, we have a set procedure which happens all over the world of briefing the tribunal in writing before hearings, obviously with pleadings or written submissions. And the way this works is a standard, often a standard procedural order number 1 that starts the process, and it will give directions to people as to filing of written memorials or pleadings. So statement of claim, then there's going to be a defense, there'll be a reply, there'll be a rejoinder, there'll be witness statements, etc. And this is an orderly process, supposedly, which reflects something of court practice. It's actually based upon the way we all practice in the common law system, which is the adversarial system. And the adversarial system is a system of educating the tribunal. That's in contrast to the inquisitorial system, where the judge takes the initiative himself or herself to investigate the facts and the law. This is was summed up many years ago by F.A. Mann, beautifully, as the principle of unpreparedness. That is, the judge is assumed to be unprepared, and you educate the judge with written submissions and then oral submissions, right? This is how it happens in practice. And there are some judges who embrace the unpreparedness much more than others. What we then do is we actually produce a huge amount of material. Lawyers draft long documents, and they do it in court as well as they do in arbitration. And they do it as a way of sending out every aspect of their case in order to not miss anything and not to be criticized later for having missed an item. And the result of this is very lengthy documents, extremely lengthy. There is an interesting anthropological phenomenon, not this law firm, but every other law firm, where you give people the opportunity of unlimited billable hours by drafting comprehensive written submissions, often by junior associates in windowless rooms who are prepared to do this for weeks on end and not have any contact with their families. And the result is very long, rambling written advocacy, long submissions, and what those submissions do is cover every possibility so that you're safe. We also have on top of that the curse of IT, which means that you can sit and draft, unlike the old days with pen and paper, where you'd have to think and then write. But we don't do that. But we don't have to think because you put everything on the screen, assuming that you will edit later, except that you don't. Because once it's on the screen, it's got a life of its own. You think, oh, we'll just keep that just in case. And then in terms of legal research, it gets even worse. Because what you do is you do searching online. In the old days, just for your information, there used to be a building which you would visit called a library. And you'll read about this in books. And you won't actually, you'll read it online. You used to go to this building called a library, and it used to have books on things called shelves. And there was a physical limitation in how much you could actually find because of time limits. And you'd have to find things that were relevant. And then if they were relevant, you would cite them. But we don't do any of that now. What we do is we put into our search engine a term, and we get 300 hits, and we chuck them all in a footnote. That's how we do it now. So the result of all of this is that we go through the standard process without thinking that in the end, there is a massive inequality between that exercise and the exercise of the audience, because the poor judge or the poor arbitrators don't have the team of nameless associates who have been working in windowless rooms. They are stuck with all this material. And they are outgunned. Judges are frequently outgunned. The experience of being an arbitrator, as with a judge, is that when time limits are reached in the course of this process, there'll be a knock at your chamber's door, and somebody will come in with a box, and there'll be a thud on your table, and that'll be a statement of claim. And sometimes then a munchie will come in with 4 other boxes, because those are the exhibits, and they all get put on in the corner of the room. And this happens 4 times: statement of claim, defense, reply, rejoinder. By the end, it's an unmanageable amount of material. Why am I saying all this? Because this is a classic example of the disconnect between the technical work we do as lawyers and the actual emotional reality. Because the emotional reality is that it's overwhelming, and judges won't admit it for professional pride, but it's overwhelming. And therefore, characteristically, when you start your opening oral submissions at the beginning of a case, there are 2 things that will happen. There are 2 lies that will be told you by the tribunal. Tribunals regularly start with 2 lies to counsel. The first lie is, we're very grateful for the written submissions that we have received so far, right? That's a lie. But there's another big whopper that comes after that, because they feel they have to say it. They say, we read your submissions. You don't need to repeat them. It's a lie. Even if they have read them, they can't possibly have managed to understand and retain all of them. So if you are now putting all this into the framework of EQ, you have to read the signs. You have to appreciate what position you put your audience in before you start making your submissions. And if you make your submissions at the wrong level, if you, whoever that was, you just lost a point, by the way. Because that's
30% of his salary.
You see, that's also an example of an EQ issue. I can be speaking to you for the next minute. I can tell you, all right, honestly, part of my mind is now in irritation mode, not personally, but it is like thinking it shouldn't be a mobile phone. But also your attention has now been diverted to what's happened over there. And that now is going to infect your concentration level. That's how EQ operates. I didn't mean this as a personal attack area, by the way. I'm very sorry to come out of the way, but that's a good example. It's very similar to the shirt triangle, where something completely irrelevant to what we're actually doing has got some bearing. And that's how delicate and sensitive EQ is in order to, and how it impacts on your effectiveness as an advocate. So where this all comes down to is to actually understand the emotional context within which you are plying your trade as lawyer, and then it impacts directly, of course, on how you do it. So we've spoken about those two, self-awareness and then empathy. The next is self-regulation. Self-regulation on top of all of this, and that is management of emotions and management of impulses that are coming from your amygdala. Actual management. That means once you've made your diagnosis of the situation, like you've understood how you're operating, you've diagnosed your audience, the next thing is to modify your activity to treat the condition that you've diagnosed. That's the next step, which we should all be able to do. There are many different ways in which you can project yourself and the way in which you can advocate. There are many different demeanors. You have choices of style. So there are different kinds of style you come across. Again, not just in a court, in a negotiation, in your day-to-day dealings. You can be aggressive, and sometimes you need to be aggressive. You might be cross-examining a witness, and you need to be aggressive. You might be being pestered by an opponent, and you need to be aggressive. You can be combative. You can be calm. You can be entitled and indignant. These are all different ways of managing advocacy. You can do my personal favorite, which is be quietly injured. Being quietly injured is very attractive for judges, much more attractive than being aggressive. You can be understated, you can be loud, and you can be jovial, or you can be somber. And you can mix and match. In one advocacy piece, you can mix and match, depending on who you are addressing. And obviously, you'll react to the tribunal. I mean, like the golden rule is, for example, the judge cracks a joke. By definition, it will be funny, all right, if you're advocate, by definition, whatever it is. So you respond in that way. You have to be flexible, and you must not just think, this is the way I'm going to do it. Now, let me give you an example. And this is going back to my first comment, which is the mistake of thinking there's only one way to do it, and one size fits all. I did an arbitration as arbitrator a few years ago in an international setting where one side were represented by New York trial attorneys. They were used to being advocates in front of New York juries, where everything has to be dumbed down and simplified. The question in the case was a short point of construction, i.e., what do these words in this contractual clause mean? I'm sitting with two other people, experienced international arbitrators. The time comes for the New York attorneys to do their oral opening submission. The doors open in the hearing room, and these people wheel in this massive board on wheels. And it's put in front of us. And on it, in font size 160, is the contractual clause that we have to construe. Because if you're appearing in front of a jury, that's what you do. So the words are in the face of the jurors. Now, that is pre-programming, thinking this is how we do it. It was astonishing for us. It was completely unhelpful and distracting, and a classic example of not going through the processes. Technically, it might be the way to do things, and that might be in the textbook on how to argue in front of a New York jury, but it's not in an international arbitration. So again, it's these processes which actually, if you think about them, they all are rather obvious, but you have to think about them. And the other thing you have to think about is your demeanor in your relations with other people around you at the time that will be observed. That's the other element to it. So when you're sitting as judge or arbitrator, you spend, I can tell you, a lot of time watching people in the room. And you will watch counsel in how they're speaking to their juniors. You'll watch counsel in how they're speaking to their clients and to their opponents, as well as how they're speaking to you. And you form a view of them. And you form a kind of all of these are elements in a jigsaw, and you get an impression of them. So the impression is not just the direct relationship. The impression is a general impression of who they are as people. I remember doing one case where lead counsel in front of me, I was sitting as arbitrator, lead counsel in front of me kept scolding his junior. And I felt unnecessarily so. Over a period of a week watching this, with this poor junior being told off the whole time in very sharp terms, in a whisper, but it's a stage whisper. Remember, it's an intense personal relationship. Everybody's looking at everybody else at length. I sensed myself a dislike of that lead counsel. I'm not saying I'm going to be affected by it. I'm not saying he's going to lose the case because of it, but it's a key element in the mix. And it's only coming from something which he doesn't realize I'm watching. And that's how he's behaving with his junior. And then lastly, there is the element of overall social skills. How do you put all of this together? It's not just how you are speaking. It's not just the words you are using. It's the whole mix of body language, other forms of communication. You can communicate with your opponent through body language. You can communicate with the judge or arbitrator through body language. So part of EQ is not just about language, it's about your overall way in which you communicate. And that's something which, of course, post-pandemic, we have become rusty, because we've had a life training normally in a professional setting, and those who have started their professional life online or have spent an intense period online, who are working from home a lot, it's surprising how much of that actually gets lost, because those are the elements of communication that we are doing without in 2D. And as an advocate, you can sense it and you can feel it. I can tell you the experience of having argued cases all the time during the pandemic online around the world, and then going back into a physical courtroom setting. It is incredible what you suddenly pick up in terms of body language that you couldn't have seen before, when you're just seeing close-up faces and not seeing overall how people are projecting themselves. Body language is not something, all these other skills are not something which are easily taught or learned. A lot of it is instinctive. What I say to people is the best training possible for all of these, obviously, is having an internship at Luthra and Luthra. That's where I learned everything. But these are things, if you are aware of them, then you start to focus on them, and then they start to become important and actually critical to you being successful lawyers. So let me end by saying that all of these elements need to be in your minds in every aspect of your work as lawyers, not just formal advocacy and formal presentations, but also as you interrelate with each other, even in a firm setting. And we know from the studies that if you are succeeding at EQ, then you will succeed. Your chances of success overall in technical legal practice will be optimized, undoubtedly. And the good news is that it may be difficult to change a low IQ. It is perfectly possible to change a low EQ. And I'll leave it at that. Thank you very much.
Thank you, Toby. That was outstanding. And friends, particularly with this whole work from home, we are losing out so much of this EQ. And especially the youngsters who have just, like Toby said, who just started their life with not even knowing what a shelf is or a library is. So these are very, very, very important aspects. I'm not saying we should go back into time. I'm saying we should at least have the sense of keeping our videos on so that we stay connected. It's a very crucial part of it. Now, I'll take a few examples that Toby had some help for you guys, for you friends. See, what is very important, which you miss out on in a Zoom call or a virtual situation, is you miss out on what are the other side hearing. You may be talking, your lips may be moving, but the crucial thing is, what have they heard? The other nonsense that we get into with this virtual story is we only listen to reply. We don't listen to absorb and then reply. I'll give you the logic, simple logic. See, if you're going to use your own brain and what knowledge you have and not listen, and you're ready with the reply, maybe you know 3 things for your reply. If you listen, you may have a 4th or a 5th. What's the harm? Secondly, when you reply, your reply will be, the other side will think of it as some value. It's not some nonsense that we do lots of times. Especially court-going lawyers have this horrible habit of repeating. Not only written submissions, but also when we speak to the judge or the arbitrators or clients, we just go on repeating and we love our voice. So short, crisp. I'll give you another example. Our corporate communication people are here. Now we have somebody asked us for our information on our capital markets. We send 30 pages, this deal, this IPO, this, that. Suppose we would just send those 30 pages, but the cover page said, last year, Luthra and Luthra did 97 capital raises. 2 listings in London, 1 listing in Singapore, and 9 listings in Nasdaq. The total deal value, $960 billion. Rated tier 1 in Chambers, rated tier 1 in IFLR, etc., etc. And that's it. And you can give your 30 pages if somebody's interested, but can you imagine the power of just that 1 page? But we somehow have developed this. The more we write, the more we get. The other problem with that not using emotional intelligence and taking a cue from Toby, we have this habit of just using acronyms or jargon. I'm an American lawyer. I don't know what the hell SEBI is. I don't know what the hell RBI is. Now, if I use the word full form of SEBI with an Indian or a person who knows, well, he'll get irritated. So you have to see the audience. But if I tell an American SEBI, RBI, we do that all the time. So we have to be mindful of who's listening, as Toby explained. So let's look at these. Simple language, very important. I'll tell you my own example. Your firm was tasked with a very, very important matter of a company which is called Monsanto. Monsanto was challenged first time at a Supreme Court level on genomics. Actually, genomics was challenged. And one, of course, angle was that genomics is, it's Agent Orange. It's bad for health, etc., etc., and much worse. There was a gentleman called Bill Hyde who was the general counsel, was in first floor, our office, and said, Luth, you lead this case. I said, I'm the wrong person to do this. We need another. He said, Rajiv, we trust you. You choose who you want. So we got Fali, we got Arun Jaitley, we got KK Venugopal, we got Harish Salvi, we got Gopal Subramaniam, we got Amarjit Singh Chandok, and there was one more, Darius Kambata. That was the lineup in the Supreme Court. And I was the junior most. Fali was the senior most. Argument begins, and we were being opposed by a lawyer. Why I'm explaining this to just tell you how something crisply said can make you reach the end and quicker, and sometimes you win, most times you win it. Opposing us, and since we are all family here, was a young lady called Indra Jaising, who's a senior advocate and who's the best way I can describe her, and some of you may have worked with her, is at the lowest of tones of her voice, she's a banshee. We had Sam Barucha on the bench, a soft Parsi gentleman singing. They're playing with nature. This is a court too. They're playing with nature. And she just went on and on and on. Then Fali, in his gentlemanly way, started, Lord Chair, we have a GIAC, and he started going into all kinds of stuff and jargon. I was convinced that judge is going to say, look, appoint a committee, injunct everything, and let it go from there, because nobody was understanding a word. Playing with nature, banshee, scary, jargon, GIAC committee, GIAC. Now, what does a judge, Supreme Court judge, know what a GIAC committee is? Maybe they do. I tugged at Fali's gown. I said, Lordship, may it please the court if I'd like to address the court. So Sam said, sure. I said, Lordship, this is very scary what we just heard. Playing with nature. Even my knees are shaking. But I've not heard a word of what's wrong with playing with nature. Now let me step back. We are all playing with nature. We are very close. Let's take our clothes off and stop playing with nature. Let's take another step back. Agriculture, playing with nature. Let's take another step back. We are alive today. Green revolution, hybrids. How much more can you play with nature than hybrids? And let's go further, 50 years. Malaria, found a cure, DDT. Today we know it's bad, but we're alive to fix it. Daily hearing, 56 weeks, I'll give you the end game. 56 weeks, Supreme Court, start to finish, 5 prayers, all 5 answered in our favor. I did 2 more little things and little anecdotes. First time in the history of Supreme Court, flip charts were used. How do you explain genomics? How do you explain DNA and all it? How? What is BT cotton? So here's how I explain. Of course, Fali and Venugopal were both pretty angry with me in the sense, not angry. They said, you're crazy, man. Huh? You don't use flip chart in the Supreme Court. I guess, how else to explain it? So what is a BT cotton seed? A normal cotton seed has 42 genes. And it needs to be sprayed with insecticides, pesticides, etc., etc. Expensive. They go on the windward side of the plant or leeward side of the plant. They go into the water tables. They go into the air. By the way, insecticide and pesticides are poison. What the scientists in St. Louis at Monsanto have done, they have found a 43rd gene, and I have fired a gene gun myself. I went to understand the technology. That's why it's very important to get to the basics and to understand how the story works. The 43rd gene, when it's inserted into the cotton seed, it becomes BT cotton. That 43rd gene makes its own defense. So when the plant grows, it doesn't need insecticide, no pesticide. The efficacy has been shown goes up to 85 to 90% of the produce. And you're not polluting the atmosphere, all of that. That is the benefit of it. Now, of course, on a lighter vein, we don't know whether that cotton seed itself, luckily it's not food, but I made one of our partners eat it in court. Because Indra Jaising said that this is poisonous. I said, sure. So one of our former partners who left the farm, Bobby Chando, I made him eat cotton in court. I said, he'll be here, he's eating cotton seed. He's saying, "Bada swad hai sir, home bhi ho." It's very tasty, give me some more. So little things like this keep the whole atmosphere. Then he talked about making it light and joke and big time. Sam Balucha and his wife were at the Indian National Center dinner. I was there too. The Chief Justice of England and Wales, we were hosting. And after in those days, I used to smoke cigars. So I used to have cigars in my top pocket. And we came out into the patio and I was smoking my cigar. Out comes Sam Balucha and his wife and says, "Counsel, that's a delicious smelling cigar." Like a lordship. They did with all the passion. And says, "Son, if there's anything I can do for you, you must tell me. This is fantastic. Like a lordship, I'm before you on my legs tomorrow. I have 5 prayers, at least answer 4. Without batting an eyelid, he says, "You think I'm so cheap? I'll get sold by 1 cigar?" I said, "No, lordship, have 1 more." Now, cut to, he's being appointed Chief Justice of India. President Narayanan was to give the oath ceremony. And the tradition is 2 independent witnesses have to be there, appointed by the president. I was one of them. And I happen to have written I happen to have helped him with his will and happened to be his executor of his will, President Narayanan. So at tea, he held my hand and took me to the chief. Said, "Chief, meet my lawyer." So Sam says, and there's Sonia Gandhi, there's Dr. Manmohan Singh, it's 20, 30 people, but all hoi polloi. And all standing nearby. So Sam, Chief Justice of India says, "Who doesn't know him? He has successfully bribed me." And everybody. Now that, if you can have that kind of relationship built, and this takes some skills and some way of figuring out what is and who is the bench, the knowledge of those are very important aspects that Toby explained. And more so now, please try and each one of your teams, all of you, get together as often as you can. Now we are opening the offices, we are getting sanitized, we are doing it's being all over the place, but we are fixing it now. It is in your interest to have this emotional intelligence built. With that, I'll open to any questions that you'd like to ask Toby or me, apart from your next bonus. Please.
Thanks for the advice, sir. I'm interning here in Luthra. My question to you, sir, is that sometimes.
No, you need to get onto a mic. Because there are other offices also listening.
Good evening once again, sir. My name is Ayush sir. I'm interning here in Luthra office today. My question to you, sir, that sometimes what happens like for fresh advocates, for the novice lawyers in court, and not only in court, but the law students and freshers who are coming for interviews. Sometimes we face like bombardment of questions from in court also and from our, of course, in interviews as well. So that affects our emotional intelligence. Of course, even when we have done our homework, but there also sometimes the unpredicted questions come to us. So how to manage those things? Like, of course, it's the human nature to get worried, and that's the point when we get worried. Of course, the person who is appointed to us is by looking to our face sees that we are worried, and that's break our confidence. And we sometimes we are knowing our answers also, but sometimes because of human nature, sometimes we forget our answers. The worst things happen. So how to overcome that? That's right.
So it's a very good question, if I may say. But let me say this: it's not just freshers. You can be in practice for 30 years and have the same panic when you are standing up in court and you've got a judge posing questions to you. So don't think that it's just because you're started out. This is the nature of advocacy, I'm afraid. The nature is, it is like an oral exam. There was a very, I tell you something which will hopefully give you courage, which I think about often. One of the world's greatest advocates in the common law world is Sir Sidney Kentridge. He is a South African who was Nelson Mandela's lawyer.
And a centurion.
Sorry?
And a centurion.
Right.
And still alive.
Still alive, absolutely, just turned 100. He's a phenomenal advocate. He has been through the toughest tribunals imaginable. Apartheid South Africa, where he was arguing for not just Mandela, but for Steve Biko, for a lot of the great independence leaders and the human rights fighters in South Africa. Then he moved to London, and he had a spectacular practice in London. I had the privilege of being his junior on a number of cases, and you could sense when he stood up in court, a bit like I think when Fali stands up in court, everybody is on edge and listening. This man was a master. I did one case with him in the Court of Appeal in London, and it was not a significant case. It wasn't massive, wasn't life-changing. It was a commercial matter. And as we walked over together to court, outside court, he paused and he turned to me, and at the time he would have been in his 80s, I think. And he said to me, you know, every time I'm about to stand up, I feel physically sick. Even for that hearing, he was feeling physically sick. This is a man who had seen everything. So you take it from that the fear that you have when you start out is not because you're just starting out, it's the nature of the exercise. And that means you shouldn't think, well, I'm at a disadvantage and I'm going to take years to get over it. In fact, if anything, that fear makes you a better advocate because it makes you sharp. The adrenaline is flowing and you have to deal with a tough situation. So how do you deal with a tough situation? That is something which you have to develop. You find a way of doing it. And emotional intelligence will tell you that you will pause and you will be looking at yourself, first of all, and you'll be thinking, my palms are sweaty. I'm doing hyperventilation. I'm wondering why on earth I ever made this career choice. I want to run away. And once you've understood that, you can then deal with it. And you focus on yourself, but you do it methodically rather than just going into a blind whirlwind.
Thank you so much.
So let me give you an example just to maybe clear this a bit better. As you all know, I'm in the middle of a lot of arbitrations and a lot of them are confidential, but in open court as well. That is almost public knowledge. I was asked a very, I wouldn't say a tough question, but I was asked something, I was put on the spot. And I was also called a very large lawyer. And I did not want to answer the judge, the first question. So I said, Lordship, before I answer, I'd like to know your posh committee's number. He said, why? I said, you're body shaming me. Please don't do that. This is open court, all collapse next. So these are little skills you build as you go along. And it helps lots of times. But you can't be facetious. That is the thing you have to see, that how will it be taken? You know, that's very important. And that is it's a bit of a gamble sometimes. So you have to be careful. But then you also have to be ready with repertoire to reverse it. Very quickly, you see it's gone wrong. To which I said, it had not gone wrong. And I was riding high. And I said, Lordship, now this is one from my side. I've given you, you have to give me one too. And continued the whole program.
Thank you so much.
Anybody else? Are we getting tea for everybody? Not for everyone, why? Mother. Okay. Anybody else? Any other question? And Rajiv, Basim? Basim?
Yes, sir.
Please open your video and check Krish's hourly billing. He's looking at lawyers in South Africa, 100 years old. There you are. I want to check what does this guy do all day.
Great.
That's brilliant.
Yeah.
I must say.
Question here.
Yeah. Any question?
Question here.
Please.
First of all, thank you so much for engaging with us and coming here. My name is Sumatri Karmataru and I'm an intern here. I wanted to ask you, as an international arbitrator, how do you expect advocates to come in front of you, and how you expect them to behave? Because at the risk of generalizing again, but still, like somebody who's new to the field, what would you expect out of them?
So it's an interesting question, because I'm not sure that I have any particular expectations, but I do have a desire, which I think every international arbitrator, but every judge also has. And that is not an expectation that they will behave in a particular way, but the desire, by the way, please do sit down and understand while I'm speaking, but the desire is to be assisted, for help. That's what I want. Every person, any judge or arbitrator ultimately wants help. They may not show it that way. They may be aggressive. They may be opinionated, but what they want is assistance from counsel to find the answer. And it's got to be an answer which will get them from A to B, i.e. from all the arguments and all the confusion and controversy to a credible, robust result, which will be a judgment and won't wreck their career. That's what they want. And what is most, and then you can get there in different ways. You can help in different ways, which is why it's not so much an expectation, because counsel behave in very different ways. And especially internationally, they behave in very different ways. You get a London barrister and you get a New York attorney, and they will approach it in different ways. And you can't expect them to do it differently, but you can ultimately just help. You can hope for the help. And the help will be, by the end of the exercise, things are clear. They're not confusing, and you've found your way through. So I think that's probably, as an advocate, that's what you should really be focused upon, is how are you really assisting in the end. And actually, just I'll say one other thing. One big confusion that people have as advocates is that they often don't think about who the audience is, funnily enough. You can be an advocate, and actually what you're doing is you are addressing things to your opponent. You're bashing them. And you're mistaking your audience as your opponent. He says this, and he said that, and that's wrong for this reason. That you're saying it because you want to put them, answer them. And the judge is in between thinking, well, I don't care, help me. The other audience often is your client, because you're there giving them a catharsis, therapy. They want you to stand up in court and say everything they've always wanted to say. So again, it's not helpful for the judge. Of course, the client's thinking, yeah, say it, and say this as well, and say that. And the judge is thinking, how is that helping me? So you've got to remember who your audience is and then help them.
Thank you so much.
I have one question.
Mike. Before that, Toby said about getting sympathy. Why do you think I carry this? This is called client craft. He taught you lawyer craft, court craft. This is client craft. That's all. So, what happened to you?
I always thought that was fear craft.
No, this has got three. It kills many birds in one stone. Partners, irritated people, sympathy. Sorry.
I'm Sanjeev Sachdeva. I'm a partner. Being a litigating partner, I do kind of strong.
But I quickly must tell, sorry to interrupt. Sanjeev was a revenue service officer, gold medalist, an MBA from one of the best institutions in the world, called the Indian Institute of Ahmedabad, and was 26 years in the government, right hand of Chidambaram, finance minister. And most of our laws that we are pissed off about, the current ones, he wrote. So, yes, sir.
That's something which we also try to do, find out about the judge, where he studied,
Yeah.
etc., etc. I was just wondering, and taking a cue from the last question, how much in an international arbitration, particularly, would we expect the arbitrator to know about the nuances of, a particular person's origins? For instance, an Indian might behave naturally in a very different way from somebody from the US.
Yeah.
Said about knowing how the US lawyer will be and the UK lawyer will be. I'm on more base things like the pronunciation.
Yeah.
Is that something which the arbitrator even tries to find out, or is that something which would then impact on the client deciding
Yeah.
which origin lawyer he wants?
So again, it's a really interesting question because it's a very important point. How much will the arbitrators actually understand the cultural differences of the council and maybe make allowances for that? Or how will that impact on their appreciation of the dynamics of the case? And I think the answer is it really varies. There are arbitrators that you put in front of who are culturally sensitive, and they will understand the way that people operate from different backgrounds. And there are those who are not, who haven't had the experience or don't have the EQ. So they themselves are very narrow-minded. And that means it's the burden on you as counsel to know who it is you're appearing in front of. Are you appearing in front of somebody who is culturally sensitive and will give you an indulgence or allowance? Or are they not? I mean, and sometimes this happens. I'll give you another example, just as a war story. It happens surprisingly how this can have an impact. I sat in an investor state case some years ago, where I was one of the co-arbitrators, and the chairman of the tribunal was an ex-president of the International Court of Justice, right, ICJ president, and he is a civil lawyer. Appearing in front of us were London then QCs on one side, very well known. So everybody's well known in this case in terms of this dynamic, and yet there was a breakdown actually. What happened was the London QC, in the way that London QCs do in court traditionally, and that is they will take the tribunal through lots of documents. So like a 3-hour opening, and they say, tribunal, please take up bundle 3, turn to tab 4, here you see the contract, and then take up bundle 1, tab 68, look at this letter, so on and so on. So we're picking up the documents and we're marking them up. It's very interactive. I sensed, for me, that was completely natural. I completely understood what was happening. I sensed that the president wasn't really following it. Isn't there like this? We then got up and we went back into the arbitrator's room, and the president was upset. And he was irritated, and he was saying, what was all that about? So why was he upset? Because he felt that this was an insult, because the assumption was that he hadn't read the papers. As a civil lawyer, that's not what his expectation was. You know, he had read the papers. He doesn't need to be treated like an idiot by counsel, saying, here's the contract, look at this clause, look at that. So even experienced people like that, there was that disconnect immediately. So what's the answer to that? I mean, obviously, counsel can't know everything about how arbitrators are going to react. But if they had done some work, they may well have moderated slightly or explained what they were going to do or somehow accommodated for that.
So Toby, how would you, this is a good point to get to know your judge, your tribunal, etc. If there's some tips.
Yeah.
One, of course, is anti-Google.
Yeah.
But one is the immediate mood, etc. Some way, ways you can judge it, and some ways you can get to know about nuances. So in-depth research in this case you just gave, needs to be done, I guess.
Yeah.
That how Americans behave, how British behave, how Indians behave, etc. So some tips on that will be useful.
So part of it is due diligence. And you can do it in many ways. I mean, apart from Google, you can actually be calling people who have appeared before these people before, or speaking to their colleagues in their home jurisdiction, word of mouth. What's this person like or not like? What do you know about them? You know, counsel are great gossipers. There is always word on the street about somebody. It may not always be reliable. But let me give you another top tip, in my view. If you can't do all that, or you have incomplete information, the next thing you do is you watch them while you are making your piece, while you start. What this QC did not do is to look at the president while he was going through this and actually pause. It's difficult, you're in mid-flow, but just think, how's this going down? How am I doing? I do that all the time. I am monitoring my tribunal because I may see that actually they're not picking up they're not picking up the bundles and not marking up as I want them to, or they look irritated, or they look bored. In my case, very often. And then you have to change. that's the flexibility of it. Then you're going to have to change pace, maybe slow down, maybe speed up, maybe ask them what they want. I mean, if in that situation, you've got a president who's sat there not actually engaged, there's nothing wrong with saying, may I just ask whether this is a helpful exercise, or you'd like me to continue with this, whether you'd like me to not do it, or perhaps present it in a different way, and ask for guidance. Now, it gets even more complicated in an international tribunal because you have a mixed tribunal often. So some people might like it and some might not. And some might be reticent to tell you, to guide you too much. They might say, well, you do what you want. But these are all things you can try, and my experience, they do help.
So on a lighter vein, at least in our local courts, I hear a lot of my litigators talk about, you must have the right pundit for the right mandit. In the sense, you don't get a priest to appear before before a Rambhakt. You don't get a Rambhakt to appear before a mosque. So I mean that's on a lighter vein, but it's a similar concept. You need to understand it, and I guess it also got to do with experience. And luckily, we have this wonderful set of souls working with us. They'll give you good, and I think they'll have most of the experiences of almost every court and every judge.
I just had a short view on this. EQ got a little left behind because of COVID, because we couldn't socially interact. But I personally feel that COVID actually gave us an insight into people's lives. We could never see how a judge sits in his house.
True.
We have a set uniform here, and every time that the judge comes to the court, he's wearing the gown, the band. Now, during COVID, when judges were sitting in their houses, there were judges who were sitting with ties. There were judges sitting with bands. You can differentiate what is the mindset of a judge in his personal space only by observing how they are behaving in their own environment, how they were sitting, how their tables were placed, how the files are stacked in their house on their tables, what other aspects do they keep on their tables. They have pens scattered around, documents not scattered around, and how things are happening, which would, I mean, ideally in a normal case scenario, we would never get to know how a judge operates outside of court in his personal living room or in his personal study. But during COVID and because of cases, and this happened with tribunals as well.
You also saw their underwear in some cases.
Yeah.
Those are senior counsel.
Also, some in depth.
I think so, you know, if someone had the art to observe for the purposes of EQ, for the purposes of connecting what you want to say in a manner that he wants to hear eventually, all these little aspects were actually quite helpful. And, you know, so what we observed then, we can still rely on today when we are in court to sort of know what the person likes, what the person doesn't dislike, what is the type of situation that he likes to be in, and that is where you would ideally want to place him before telling him something. So I personally believe that, you know, COVID, and it's not judges, tribunals, it's our clients. Because we had so many, all our client conferences were happening through VC. So how the client also interacts, sits, moves around in his personal settings, I think so it gave us a lot of insight which Google or most search engines wouldn't have been able to give to us.
I completely agree. I mean, it was absolutely, you know, anthropologically fascinating seeing judges' homes. And seeing like, you know, an odd thing sometimes, like kind of, you know, an odd picture on the wall or something. It's like really revealing of something about them. So that was pretty unique, and we've all got, you know, our own anecdotes. So there were some fantastic moments during the pandemic of seeing bizarre things happening behind this, you know, behind the judge. I think I told Rajiv the story of, was doing a lot of work with Sri Lanka, the Sri Lankan government in an international dispute. And the Sri Lankans are very, Attorney General's chambers in Sri Lanka, very, very polite, very, very prim and proper people, very old fashioned, really, really lovely people, very, very sort of conservative. And there's one chap I was dealing with a lot, and he would always appear on screen, very, very formal, with a white shirt and black tie and black jacket, absolutely precise, except that behind him at home, his manservant would be regularly mopping the floor half naked with a sarong and a very large tummy. And he'd be mopping like this all the way around back. And you could see like the whole scene that was going on behind, which had this other dimension to this wonderful chap who was just there as if he was in the office in front. So we don't have that luxury post-pandemic. But what it shows us, I think, is that, right, you don't have direct access to that kind of information, but you have to find it in other ways. So that's, we've had that fun, but now you have the challenge as a detective really to pick up on other points, to try and piece it together without actually seeing their front room.
So Nakul, every situation it's all bad is not the case. There will be some benefits we'll have, but now you try and see the balance. Appear in court where I'm in person and you're on virtual. Don't you have a disadvantage? I'm before the judge and you're virtual. Think about it.
I absolutely don't think it's a disadvantage.
The virtual one.
The virtual one. There's only one bottom line to advocacy, which is you have to say what your client wants you to say in a manner that the judge wants to hear. It's a very bottom line. You have to know what is the opening line, what is the first word that will get his ear. No matter you're speaking from back of the room, from a VC, from the left or the right, if you know what is to be said, he will hear you.
No, I agree.
Totally disagree. Because everything that I've been saying is it's not just the words, because those words will have a different impact depending on the whole surrounding package in which they are received. You can say those words, which might be brilliant words, and you say them remotely over a connection in 2D, and they may not actually register in the way that you need them to register. The words may not change, but the actual physical, if I say now in front of you, looking at you, eye-to-eye contact, and I say something to you, in the particular setting, I can make it 1,000 times more powerful than if I'm looking at you as a little blob on my screen, which might or might not be in focus, with audio that might or might not be good, with other things distracting me around here. I think there's much more to it than just the words.
They're not just the words. You have to say the words that he will hear.
In a way that he will hear. Yeah.
So the key is, even if I'm saying it over VC, I need to have the words that will get his ear, no matter how much distracted he is, no matter whether I'm on VC and someone else is there physically, I may be at a disadvantage to start off. But if I have the key to the lock, I will be able to open it. If I don't have the key, then it can't.
But I think what you're saying is that, of course, I mean, you can't win a case without arguments that are going to succeed.
Yeah, but it has to. The arguments ought to flow in a manner that his ears are open to hear. I think so. The ear is nothing but a lock. You need to have the right key, and you need to use it extremely quickly in those circumstances to open them.
Interestingly, promise for too long. But interestingly, what some people were finding with advocacy over Zoom, 2D advocacy, is that you have to be even more concise than you would if you're in person. So the way that you say it has to be attuned to the fact that actually their attention spans are handicapped by the technology. You can only watch for so long, and the impact might not be so direct because other methods of communication are missing. So the result is your submissions are even shorter and even more to the point to make that impact.
They're shorter, more to the point, but even more difficult for a judge or an arbitrator to consume still, despite being shorter and concise, because everything that happens in between an argument gets all skipped out. So there's a lot of.
Sorry to interrupt, you're right. Point is, see, go for apples and apples, not apples and oranges. If you know what the judge is hearing and you know that opening the key, now what is better, virtual in opening a key or physical? That was the point.
In that, it's physical.
That was the only thing I was saying, that that's what it's, we are losing out on that. And if all of us, I'm repeating, which I said myself, we shouldn't repeat, but Sangat ka asar ho gaya, which means so anyway, any other questions? Yeah, Mike.
Hi, Neha. So Toby, do you have any observations on the use or application of EQ at an organizational level? So the way the management functions or the way we function with our teams, as everything that we discuss is more on a one-to-one level. From an organization perspective, do you have any observations?
So I think everything that I have said defines relationships, whether they are advocate and judge, or partner and associate, or group and group. I mean, they are all relevant. These are all basic human manners of behavior that apply in all these different contexts. So I think in the way that you relate to other people within the group structure, you'd be thinking through the same steps, the same issues. It's all, each of these steps of self-awareness and empathy and modifying your own behavior, they obviously apply, even just in a day-to-day group setting within a law firm. I think one would think about it exactly the same way. You'd be, it's not necessarily you're seeking to persuade people all the time, but even in your relations with them, it's an interpersonal relationship which has exactly the same facets.
I mean, for example, how do you, if you have only had a virtual connect, how do you get loyalty? It's just, another, these facets of building an institution and feeling part of it. Virtually, yes, they are, I mean, it's not an advantages. How many more meetings we can get under our belt? But how effective are they, the physical meeting and the virtual meeting? Now, some typical shouting ones like I do are very effective. But then they switch off the very microphone or the speaker, and I can keep shouting. And I'll give you one lighter one. My youngest daughter, Arshia, she was on the school damn thing, and the teacher's talking away, and she's quiet, as if she's frozen. I walk into the room, and the teacher's saying, Arshia, Arshia, and she's just frozen. And she looks at me. I said, you shithead, your fan is working in the back.
We just kind of one more point. I mean, I think part of the, maybe one of the core elements of what I've been describing is the extent to which you are understanding somebody else in order to kind of get the best out of them. And that's, so in an advocacy setting, it's about persuasion. But in a day-to-day setting, it's also about maximizing or optimizing the working relationship. So you'll only do that if you really understand how the other person operates, how they tick, what makes them, what's going to be best received by them, what will put them in a position where they'll be working at their optimum. And that's all, that's all depends upon the relationship.
Right, but it gets complicated when you're working with groups, right?
Yeah.
Because I may understand the background or the nature of the personality
Yeah.
of a person, which may not be similar to B and C and D. And the larger the group, the more difficult it becomes.
Absolutely, because of the group dynamic itself. So where the complexity comes is you have to do both really. I think you have to understand and go through the steps on a one-to-one basis, but you also then have to factor in a group dynamic. And how do people operate, not just by themselves, but when they are with their peers or their colleagues. And you see that even, I mean, even in an adjudication setting, there are group dynamics. So I just have to mention one thing, because one of my favorite psychological phenomena, which has been the subject of research, and one can observe it very frequently. If you've got 3 arbitrators or 3 judges, the way that they operate will not just be how they are individually, they operate together, and they have their own group dynamic. So there is this concept called social loafing. Social loafing. And social loafing happens where you have got a group of people, and some people, you've got a group of people where accountability is dispersed amongst the group. So no one individual is actually accountable. And possibly you have a leader who will be accountable, like the presiding judge. And once you've got somebody who's identified as the person who will be accountable or taking the lead, social loafing is where people take their foot off the pedal. They don't actually engage in the same way, because ultimately their neck will not be exposed, and the person, somebody else, is going to take the weight of it. And that means they actually may not engage with the argument anymore, and they may start drifting off. So again, it's if you know that as an advocate, you're taking into account not just that person as a person, but that person interrelating with the others. So it just shows that there is a group dynamic, which is another factor that has to be understood.
And that kind of normative behavior that you see at you. So, figure it out over here.
I'm just curious actually. So in your journey of EQ, you explained that the first step is self-awareness. Now with the pandemic happening, a lot of focus coming on mental health and people finally having the time to stay still and think about themselves. I would personally say that has really helped achieve on a very collective level the first step of self-awareness, also having experienced loss at such a collective level. So I'm just curious, like in practice, do you see that coming out, like the difference from pre-pandemic to post-pandemic, how people now are more empathetic about their interpersonal relationships with others? Is that a very profound difference that you see, or is it again the same level as before?
I agree with you. I think that the pandemic has been a total change in tempo for everybody. And for a lot of people, that has opened them up perhaps to a period of reflection, which they've never had the luxury of before. And that's a factor of time, a factor of isolation, a factor of some things being slower than they were before. And that's had a positive and it's had a negative, obviously, because it's also exacerbated mental difficulties or issues with people, and they've been probably the fact of the stresses themselves. But what I'm not sure about is whether that will last, because now we've come out of it. As we get back into the workplace, especially in our lives as lawyers, that privilege of time gets lost pretty quickly. You start actually to get back into your routine, and you start traveling again, you start going to court again, and you start with deadlines, and the pace is no longer a lockdown pace. And I wonder whether we've really retrained ourselves, or whether we'll see this as that was a period where we had that luxury, which we don't have anymore. And so we're now back in the rat race. And I think it's one of the problems actually with lawyers, or they probably are so bad at EQ, is that we tend to live our lives from one deadline to another with lots of different demands on our time. And what gets put on completely on the back burner is this kind of self-reflection.
Thank you so much.
So let me give you my personal experience. So at least I thought one of my strengths was I'm a people's person, and I get to know people, I get to bond with them, and I enjoy it. It's like a passion with me. What this pandemic has done is actually split that completely. A lot of the newer ones, the people who joined the firm, even now, I try and meet you all physically, even the interns. I try and do my little bit, but it's not the same. That bonding, that knowledge of the person, and a lot of times I actually get irritated when I don't remember the name. So when I see you on screen, and firstly you have some iPhone 7 written over there. So that's another lesson. We must have a proper identity. So, you know, these little things, if we can, and that's what builds, these are blocks, the way I see them in my experience. And what I don't know, all of you youngsters who are meeting each other probably, you know, intermittently, your bonding or your connection will take much longer. Is my view. I don't know what everybody else thinks.
No, I don't know anyone who enjoyed a drink over what to do.
I did that a few times.
Yeah, but you didn't enjoy it as much as
Yes, yes, yes. Well, thank you very much, sir.
My great pleasure.
This is absolutely an honor to hear you. And that's another skill you have to learn is wit. And how do you turn around things? And these are little nuances you pick up. I learned one thing from him at a SIAC conference. He was in a debate, and it was all over the bloody place. Suddenly he says, you know, in Cambridge, there are these parks, there is crisscross paths, and there's a tail lamp there, a street lamp. Let's focus. You know, he's all over the place, and suddenly he said, let's focus. Nothing to do with the debate. You confuse the hell out of the judges, and then suddenly go on. So, you know, those are, and again, listening, not to reply, but to absorb. When I started my career, I had no senior. I couldn't listen to anybody other than I figured it out. I'm a little, you know, mathematical that way. I said the most important thing in the life of a lawyer is ethics and integrity. So who is the most ethical? And Jennifer, he's finishing. Can we get his, you give me your car keys? So give him your car keys. So I started to follow Fali Nariman. And I started to follow, I'd never met them. I would often, when I'd get time, I'd go and sit in court, just listen. And of course, unfortunately, the second person I tried to follow was Gopal Subramanian, but I couldn't follow his language. So that was a bit of a challenge. The other gentleman was Nani Palkiwala. So he was in Mumbai, but whenever I got the opportunity, it was a delight. And learned a lot from them. You learn a lot by listening. Again, that's a very important aspect.